Hello, everyone. I will kick off our CANON webinar. My name is Suzanne Morin. I'm VP and Chief Privacy Officer at Sun Life. Welcome, everybody. Our panel today, our session today is called Perspectives on Regulating De-Identified Data in Canada. Some might say even the title of our seminar today is controversial in a couple of ways. One, talking about regulating, and two, should we really be speaking about de-identified data or rather levels of identifiability? And we'll be hearing more about that in a moment. We've got over 85 participants registered here already, participating already. We actually have 330 people who have registered, so hopefully we'll get a good number of those attending today. Welcome, everybody. We have individuals, just like CANON, we have individuals from the public sector, from the private sector at both provincial and federal levels, as well as academia, and so welcome everyone. This session is being recorded and will be posted both on the CANON YouTube channel, but also a link will be provided off of the CANON website. And you can see the link in the chat. Attendees, unfortunately, you are muted throughout the whole session. However, you can ask questions, and so I invite you to do so. And the chat is not disabled, and so you can comment in the chat, and so please do so. There are two parts to our event today. We will start off with a presentation and discussion with Ontario Information and Privacy Commissioner Patricia Kosseim, followed by a moderated discussion between Adam Kardash from Osler and Keren Groll from TD Bank, who will provide a private sector perspective. But first, really just a quick backgrounder on CANON. CANON is a broad and inclusive network across multiple sectors comprised of large-scale data custodians with extensive practical experience managing or using data. There are two levels of membership, our steering committee members and our general members. And I'm glad to say that our participants today were all members of the on the steering committee. And we are all big believers and promoters of CANON. Pat Kosseim, who used to be on our steering committee, you can see has moved on to bigger and better things. And so that bodes well for CANON members. It's been a pleasure of mine to work with Pat, Adam, and Keren to see CANON's birth and evolution. I invite you to visit CANON's website and just some of the things that we've been up to over the last actually couple of years. There are FAQs on the website. We've issued a couple of newsletters. There are various submissions to different levels of government when it comes to policy development, also standards development with the CIO Strategy Council. There's a submission there. There was a project funded through the Office of the Privacy Commissioner of Canada's Contributions Program and a report coming out of that titled Practices for Generating Non-Identifiable Data. And we've hosted some events. There was a COVID mini summit in June of 2020 last year. And we had a webinar in July this summer speaking about the OPC's project. And so without further ado, what I will do is I will ask Pat to join us. And she's going to give us perspectives from both a private and public sector. She'll do a little bit of quick level setting for us on some of the changes we're seeing in legislation, focusing in particular on what she's seeing in Ontario. And she's got some proposals for us. So over to you, Pat, for about 20 minutes, and then we'll come back and try to answer some of the questions that we see in the Q&A. So over to you, Pat.
Thank you so much, Suzanne, and thank you to all the CANON members for having me. I really appreciate the opportunity to participate in this discussion. I am a big fan of CANON, and in the interest of full disclosure, as you mentioned, Suzanne, I was one of the 3 founding directors along with Adam and Khaled, so I'm not exactly the most objective when it comes to my praise for your work. But long before CANON and throughout my career, I've supported the privacy respectful use of information for innovative and socially beneficial purposes, such as health research. And I understand and appreciate the role that privacy enhancing technologies play, such as de-identification, in helping enable this. Like many of you, members of CANON and participants here today, I'm also a very pragmatic person. Theory, of course, is important, but practice is really where the rubber hits the road. which is why I appreciate the objectives of CANON and its purposes, everything from the use cases for de-identification, which you've done, to your ultimate end goal of creating a Canada-centric code of practice. All of these are highly practical outputs, which are and will be of broad applicable use. So I encourage you to stay the course, and there's a lot of good work ahead yet to be done. So as you mentioned, Suzanne, I am going to start with a bit of level setting, which will help set the stage for our discussion this afternoon. I'm going to assume that this audience has a good understanding of most Canadian privacy laws, which until now have been based on a binary concept of information as either being personal information, which by itself or in combination with other information can identify an individual and therefore is subject to the law, or de-identified information, which cannot reasonably be used or combined with other information to identify an individual, and typically, therefore, falls outside the ambit of the law. But without a bright statutory line or threshold between these two states of information, determining whether information is or is not identifiable often falls to other instruments like guidance from regulators, investigatory findings, and jurisprudence. And unfortunately, this continuing fuzziness in interpretation inevitably results in either risky information management practices that fly completely under the radar, or reticence risk, impeding a fair competition and really healthy innovation. However, we are seeing this binary state of information starting to change towards a three-state model. Quebec was first across the finish line with Bill 64 that introduced new definitions for de-identified information and anonymous information. De-identified information is information that no longer allows an individual to be identified directly and can be used within an organization without consent if it's necessary for study, research, or statistical purposes. Bill 64 also defines anonymized information as information that irreversibly no longer allows the person to be identified either directly or indirectly, and therefore is not subject to the law. And this, of course, tracks very closely to the three-state model put forward in the GDPR, although under the GDPR, the terms pseudonymization and anonymization are used. The now defunct federal bill, C11, also introduced an explicit definition for de-identification, which means to modify personal information by using technical processes to ensure that it does not identify an individual or cannot be used in reasonably foreseeable circumstances alone or in combination with other information to identify an individual. Bill C11 would have permitted the use of de-identified data for explicitly stated purposes, such as prospective business transactions, internal research and development, as well as certain socially beneficial purposes. Of course, this definition of de-identified information begged the question of when, if ever, information would be sufficiently de-identified as to fall outside the law, so it could be used for other purposes as well. We have yet to see, of course, what, if any, changes might be introduced in the successor bill. But let me turn now to other developments, more specifically in Ontario, that likewise show a movement or an attempt to better refine definitions and clarify expectations of what can or can't be done with de-identified information. So let me start with PHIPA, the Personal Health Information Protection Act. First, PHIPA has a very useful provision that explicitly permits health information custodians to use personal health information without consent for the purpose of modifying the information in order to conceal the identity of an individual. Now, this provision remarkably turns out to be very useful in that it helps break the vicious cycle and sometimes the ironic requirement of having to obtain consent in order to de-identify information so as to be able to use it without consent, which sometimes can get quite protracted. Moreover, PHIPAA has seen two relevant changes, additional changes over the past few years with respect to de-identification. In 2019, PHIPAA introduced a general prohibition against using or attempting to use de-identified information to re-identify an individual, except for a limited class of organizations, including health information custodians and prescribed entities, persons, and organizations. And it's an offense for those who willfully contravene this provision. Again, this offense provision is extremely helpful in terms of garnering trust that de-identified information will be used and can be used without malicious intent. So that's certainly a welcome addition. Then in 2020, PHIPAA was further amended to allow for the development of regulations around the requirements and standards for the de-identification of personal health information. Now, of course, that's a critically important provision, and we're still impatiently awaiting that regulation, which will be very, very important to the continued administration and implementation of PHIPAA. Let me turn to our public sector law, FIPA. In 2019, the Freedom of Information and Protection of Privacy Act in Ontario was amended to include Part 3.1, having to do with data integration. Now, this new regime sets out a privacy protective framework to enable data integration within and in some cases across ministries. Prescribed data integration units, they're called, are permitted to collect personal information for the purposes of linking data and enabling access to de-identified data sets for the purpose of analysis in relation to things like the management or allocation of resources, the planning for the delivery of programs and services, and the evaluation of those programs and services. The legislation, as well as the related data standard, which was recently developed, completed, and approved by my office in April 2021, sets out specific requirements and restrictions for data integration, including very specific rules around linking and de-identification. Things like segregating duties in relation to coding and linking, transforming personal information collected by the data integration unit into coded information as soon as reasonably possible in the circumstances, linking only coded information together where necessary for analysis, and then de-identifying the linked coded information prior to analysis. So that's a very interesting and helpful standard, and I invite those of you to have a look specifically at the de-identification section of that standard. Turning now to the private sector. As many of you know, of course, Ontario has been considering the introduction of a provincial private sector privacy law. And when the government issued its first discussion paper on this topic, or introducing the idea, the IPC proposed a scheme that defines a threshold at which information is considered de-identified, but still subject to privacy legislation, and afforded greater flexibility for its use in defined circumstances, and another threshold at which information would be considered anonymized and therefore outside the four corners of the law. The government's subsequent white paper did adopt this three-state model of personal information, de-identified information, and anonymized information. At a subsequent stage of consultation, when the government issued its white paper, we, like many of you, filed a response or a submission in which we made some specific recommendations with respect to de-identification, which I'll just run through a few of those now. First, we recommended that the proposed definition of de-identified information be amended to include a threshold, or to include as part of the threshold the concept of reasonably foreseeable circumstances. And we thought this would motivate or require organizations to adopt the appropriate governance mechanisms, either internal or external to the organization, which effectively and securely segregate de-identified information from any other information that may be used to re-identify an individual. We also recommended differentiating between anonymized and de-identified data by specifying that de-identified information still presents a residual risk of re-identifying an individual. And we thought this would help organizations more clearly understand when information remains subject to or falls outside the scope of the law. Defining anonymized information as information that presents no risk of re-identifying an individual might be a contentious recommendation, particularly within this group, knowing that some, in fact, many might argue that it's virtually impossible to remove all risk of re-identification. However, we believe that data can be irreversibly modified, and some forms of statistical data can be sufficiently aggregated so as to remove any real risk of re-identification. Moreover, having a definition of anonymized data also leaves open the possibility for some emerging privacy-enhancing technologies like synthetic data, for example, to eventually attain or reattain a state of anonymization while preserving some measure of data utility. So we certainly think it's a reasonable balance between protection on the one hand and permission to innovate. But of course, we'd be happy to hear your feedback on this. We also propose that any private sector privacy law should explicitly set out in the application section which provisions of the law continue to apply to de-identified information and which don't. So for instance, we recommended that provisions relating to organizational accountability, fair and appropriate purposes, safeguards, openness and transparency, and challenging compliance should continue to apply to de-identified information as defined. We recommended that an Ontario law should incentivize organizations to de-identify data as much as possible. For example, when de-identification is used as a safeguarding measure, this could be a due diligence consideration or a mitigation factor when assessing compliance and applying the enforcement measures more generally. Lastly, I would just bring to your attention the importance we recommended be placed on transparency around de-identified information. Individuals whose personal information will be de-identified to advance other purposes have a right to know what these other purposes are, particularly if there are residual risks of re-identification, and particularly where there may be group harms resulting from attribution. So much like investors who avoid putting their money in investment funds that are not aligned with their ethical values, why shouldn't individuals have greater visibility into what will be done with their personal information and at least be given the option, wherever possible, of avoiding organizations that engage in what they believe to be objectionable practices? At the same time, legislation should support transparency to the regulator. This includes requiring organizations to maintain records of their de-identification processes, and this could be part of a PIA, for example, that would be made available to a regulator upon request. Finally, as you know, the white paper, like Bill C-11, set out a regime for development and recognition of codes of practice and certification programs. And I think codes offer a great opportunity for building trust and providing concrete guidance on how to effectively de-identify data without losing its utility for defined purposes, and having regard to the specific context is a subject that lends itself very well to the body of a code of practice. So I really do hope that CANON is able to pursue its work in this regard in developing a code of practice, either on its own or working with others, and other groups like the CIO Strategy Council and others who may be mutually interested in moving in this direction. So where do we go from here? As you know, earlier this year, my office announced the priority areas it will seek to advance over the next 5 years, including privacy and transparency in a modern government, trust in digital health, children and youth in a digital world, and next generation law enforcement. The first of these two priorities, modern government and digital health, will in particular be impacted and stand to benefit greatly by a commonly understood, workable, and practical understanding of de-identification. As you're all aware, the IPC issued our de-identification for structured data guidance in 2016, and I think these guidelines have served us well since. I'd be interested in your views on that. And I think they remain quite a valuable resource. However, given the important role of de-identification or other privacy-enhancing technologies, particularly the role they'll play in advancing our priorities, we're already setting our sights towards the next iteration of those guidelines, and we're exploring potential follow-up. And I'd be interested in hearing your views on some of these ideas. So let me put some options out before you today. The first would be to supplement the existing guidance. The IPC has now had 5 or more years of experience applying the guidelines in the context of both investigations and consultations with stakeholders, particularly public institutions. And perhaps the most obvious option for updating the guidance would be to draw on lessons learned, creating a supplementary document which sets out, for instance, key takeaways from de-identification related investigations and practical challenges encountered by organizations in having to apply the guidelines, along with lessons learned in terms of how they were overcome. Another option would be to focus on governance. So the most prominent part of our current de-identification guidance is the 9-step explanation of the technical de-identification process. This is followed by a briefer description of the de-identification governance, setting out a bulleted list of potential activities organizations may want to consider implementing. So one option would be to expand on this discussion of appropriate governance frameworks for de-identified information, focused more specifically on the administrative measures like effective segregation of functions and duties and ethical oversight. And this might help organizations who proceed to use de-identified information for internal research purposes, while also maintaining the key to re-identify individuals so as to give purposive a meaning to the reasonable foreseeability test. So really focusing in on those internal and governance frameworks. Another option would be to expand our sites to other privacy-enhancing technologies. So this group in particular is well aware that while de-identification is often used as a generic term for reducing identifiability, it's also a very specific technique. And our current guidance focuses on that technique. And so maybe there's a third option for us, which would be to work in collaboration with others to expand our focus and to look at one or more other privacy-enhancing technologies or processes. For example, we might have a similar deep dive treatment to the process of creating synthetic data or homomorphic encryption, depending on what stakeholders and what our research tells us would be the most relevant. And finally, another option would be to look beyond identifiability. For instance, looking further into what a privacy law of the future might look like beyond the concept of identifiability. So concepts such as group privacy or community ownership of information, as we've seen in the First Nations principles of OCAP, or the EGAP framework for health data collected from Black communities. These kinds of frameworks and principles are emerging areas of discussion that suggest that whether an information is about an identifiable individual may not be the best, or at least certainly not the only question to ask when determining whether a person has interest in the data. And perhaps we need to turn our attention to mitigating against the possibility of things like attribution disclosure or the disclosure of attributes related to groups of individuals that may be stigmatizing to individuals who are members of those groups. Again, this would be an area of exploration, potentially resulting in further work or recommendations on a more expansive concept of interest in data beyond identifiability, and we put these ideas out there for your input and your consideration. So of course, I welcome any thoughts or suggestions you might have on what our office may do and how we can best contribute to this space and in moving forward the discussions, and practical guidance on de-identification or other privacy enhancing techniques. And of course, I welcome that either today in this afternoon's discussion or any time after today. You can feel free to reach out to us, and in particular, contact Vance Lockton, a senior technology advisor with my team, who is the lead on this file. Many of you will know Vance, and feel free to reach out to him with any suggestions you might have. So with that, I thank you, and I will hand the floor back to you, Suzanne.
Thank you, Pat, for a great overview and sort of mini deep dive into all things Ontario. We do have, maybe before I start with actual conversation with you, we do have a few questions. And so I'll just sort of take them in order here. So one we got fairly early on is they're interested in your opinions and reasoning on whether machine learning models should be considered personal information, and should the application of privacy enhancing technologies or PETs like differential privacy, like you mentioned, to such models affect your opinion or judgment?
Big question. Maybe we can keep that one for the panel discussion later, because I would love Keren and Adam's views and Khaled's views on this. How about I reserve on that one and reflect a little bit? That's a big question.
It is for sure. Okay, so Adam and Keren, you've now been put on notice. We're going to come back to that one. There were a couple of questions in the chat here. So with availability of rich data everywhere, have you considered any metrics to ensure that that they are de-identified at least to an acceptable level? I know you spoke about reasonable in the circumstances. Have you given any thought to what, sort of what those metrics might be?
Well, I think certainly our guidance that was issued in 2016 works through a process of both technical de-identification as well as governance mechanisms, and that was heavily informed by the work of people like Khaled and others whose work is instrumental in this area. So that is the question of the day: is the appropriate thresholds, particularly as the questioner put it, given the rich volume and of data that is available. So I'd be interested, again, not to punt the question, but this is exactly the subject of today's discussion: is what are those appropriate thresholds? We have examples of Bill 64, GDPR, C11, the Ontario White Paper proposals, and I think some of them are certainly helpful in moving towards a three-state model of personal information, or of information that recognizes not one, but actually two thresholds. of information. So very interested in hearing what others think about that and whether that's actually a helpful movement in the conceptual thinking around regulation in this area or not.
Thanks for that. You know, Pat, you mentioned early on in your presentation some of the impacts we're seeing or consequences of having that binary approach of either you're in or you're out. And you mentioned reticence risk. You know, just take that a little bit further and how you think the three-state approach maybe helps with that. And while you're doing that, also think about, is it really necessary to regulate that middle state? You know, you have in and out, but the middle state, is it necessary to regulate the middle state? Or is it possible through best practice and guidance and things like that? Because, you know, whenever you add regulation, every word means something, and that in and of itself can introduce uncertainty, even though you're trying to introduce certainty. So let's talk a little bit more about how that three-state for information might actually help with that reticence risk.
I think it will. I think it will because if there is this three-state model, I think organizations will find themselves more often than not in that middle state. And at least then the rules, you know, they have to worry less about which state they're in and get on with using the data in obviously acceptable ways. So I do think that organizations would, with that assurance of knowing where they stand, will be able to proceed with innovative uses of data, recognizing that there are rules in place, and precisely because of that recognition of that middle state, those rules are more flexible, provide organizations greater flexibility to do with that data things that, you know, they may be able to do without consent. And the quid pro quo for that is still some level of, obviously, of accountability, of transparency, of, you know, individuals being able to challenge compliance, those provisions, safeguards. Oh my goodness, that's really important because, as you know, you could navigate and shift from one state to another very easily, depending on the change in your security safeguards. So I think that that's reasonable. I think that most innovative organizations would understand that those principles would continue to apply quite reasonably. I think the big sticking point is the consent. And once you get that clarified, and then, as I said, you can get on with it. And I think there would be less reticence risk as a result.
And would you say that that would apply equally in the private and public sectors? Or should apply equally?
I think so. I think so. I mean, I think that, you know, where it gets interesting, and C11 started that discussion, is this idea of socially beneficial purposes, even among private sector organizations. So that's really an interesting introduction of an idea that, you know, even in private sector, there are innovative uses that are socially beneficial, and that there are conditions under which de-identified information can be used for those purposes, bearing in mind, you know, the risks, but bearing in mind the benefits as well. Mm-hmm. So, yeah, that concept of socially beneficial is really interesting one to unpack, and certainly one that will be interesting to see either in the white paper or in the future, or the next steps of the white paper, or whatever successor bill comes out of C11.
Great. I actually got two more questions here. So as part of the Ontario consultations, has there been anything in Ontario legislation or proposals that require algorithmic impact assessments, given the known risks and issues related to data bias and data quality. And, you know, a lot of people like to say that there's no ethics police, there's no bias police out there. Different regulators are trying to fill the void. Anything in Ontario in that regard, Pat?
Well, I would invite you to look at our submission to the white paper where we do introduce this concept. We did recommend this idea of accountability in respect of algorithmic use, automated processing, and we did give quite a bit of thought to this sort of next generation of accountability beyond the privacy impact assessment. Many have written about this before, and I think I think necessarily we need to be able to design those novel accountability mechanisms to deal with, commensurate with the new qualitative and quantitative level of risk introduced. So I would have a look, if you're interested, at our submission and what we had to say about algorithmic impact assessments.
I think we have time for one more question, and there's one in the chat here that in the Q&A that we can also take over to the next session. But the question is about monetizing data and how are regulators addressing potential monetization of personal data collected by public sector government institutions? And sort of connected to that is, what about the sale of the de-identified data, either in the health sector or private sector? Should that be allowed? And should there be, and obviously, what would the impact be on the increased risk of re-identification if that were to take place?
Yeah, that's a really, really good question. I think that invokes a couple of really important points. One around transparency. Again, going back to, once data is de-identified, there is this compelling case for having to be transparent with what you do, even with de-identified data that was derived from personal information collected in the first place. So I think transparency is the real key, quid pro quo, to any prospective disclosure, let alone sale of de-identified information, particularly from public institutions to private institutions or private sector. So yeah, that to me is extremely important, and is the minimum key requirement for individuals to be able to make reasonable choices, not about what's done with their de-identified information necessarily, because we may not be in a space of consent in that situation, but whether they prefer to deal with other providers who don't engage in sale of de-identified data that they may find is objectionable. So I think it has to do with consumer or citizen choice, and that transparency is a way of empowering them to make those choices.
Pat, thank you for that, and we're bang on time. So thank you very much, and thank you everybody for your questions and comments in the Q&A in the chat. And any that we haven't answered now, we'll try to pick up at the end. So with this, I will invite Adam and Keren to turn on their videos. And Elizabeth, if you could maybe put up the slide presentation that Adam's going to use. And, I'm not going to spend too much time here for introduction, other than we will try to save the last 10 minutes to bring Pat back and have a four-way conversation. So over to our private sector perspective, over to Keren and Adam, two experts in this field. So over to you.
Thank you, Suzanne.
Just as Keren goes in, just one point for Elizabeth. The slides will go up after Keren is completed her comments. Yes. Thanks. Sorry, Keren, for interrupting.
Not a problem. Good afternoon, everyone. I'm going to begin the session that Adam and I are presenting by making a case for why de-identified data should be contemplated by privacy laws. And yes, I work in the private sector, and I am making a case for regulating. So as Commissioner Kosseim mentioned, PHIPA in Ontario addresses the concept of de-identified information, and it's been tweaked over time as they learn and practice to make enhancements to how to regulate de-identified information. But private sector privacy laws outside of the healthcare space do not typically address de-identified data. And the confusion around de-identified data and whether or not to fit it into privacy laws and how is in part due to the concept of identifiability. Because privacy laws typically govern what's called personal information. But the definition of personal information is not binary. It's hard to say whether or not something is or is not wholly personal information. Instead, identifiability is a relative concept, and it requires a contextual evaluation and really should be thought of falling along a spectrum where at one end you have personally identifiable data, and at the other end you have complete anonymity, and then everything in between is contextual and it depends. So when you think about it that way, and then coupled with consent, which is the cornerstone of Canadian privacy laws, there are good reasons why the concept of consent should not apply to the act of creating and also using de-identified information within an organization. And there are several reasons for this. Businesses need to be able to analyze data to innovate in order to serve and understand their customers, to create new products, to compete on a global scale. And de-identification is one technique of doing so in a manner that protects their customers. And at the same time, the concept of consent in and of itself is rendered hollow where customers receive these really lengthy forms of privacy notices that describe a lot of common uses of information, including several de-identified analytical type uses that don't actually impact or affect customers, and customers have no meaningful choice when it comes to that. So it's not really a consent. And then importantly, most individuals then disengage from the privacy policy because it is so long. And, you know, if you actually had to make that subject to consent, like if a customer complained and a regulator said, listen, no, like you need to give customers a choice to opt in or opt out or be part of your analytics pool, that in and of itself would be very significant. And that's because, you know, the systems and programs and machine learning algorithms that rely on this data, they need a large volume of data to correctly identify trends or gaps. And there's some issues related to accuracy and bias if the underlying information is not an accurate reflection of the population being studied. You know, we've all seen examples of this. You know, Amazon created a hiring algorithm that reviewed resumes, and Google created a speech filter. And both of these products showed that with incomplete or inaccurate data, it affects the calibration of the data tool so that some data traits are weighed more heavily than they should be. And then the results of those systems to exclude certain recommendations are also problematic. So, you know, in practice, the current definition of privacy law today in PIPEDA and in various provincial legislation that applies to the private sector does encompass a range of de-identified data. There's case law that says, you know, even if it's de-identified but is reasonably foreseeable, as could potentially, even with information you don't have, that you could have, be re-identified, you're caught by the act. And therefore you're caught by consent and all sorts of other provisions. And it's this that, as I said, creates really opaque and very frustrating privacy policies. And, you know, some of the goals of the modern privacy reform that we're seeing now are to shorten these policies and make, you know, privacy, consent, and onboarding a meaningful conversation with the customer. This is how we're going to use your data. Do you agree? And the only way to do that is to take these common uses or areas where there's no choice wholly out of the equation. And the intent of regulating some of this spectrum of de-identified data is to ensure that organizations remain transparent and accountable for their use. So it's not carte blanche, de-identified data, off you go. And I think Commissioner Kosseim made the same recommendations for Ontario, that certain sections of the privacy law should continue to apply: transparency, accountability, safeguarding. But other aspects of privacy regulation should not apply, such as consent, but also there should be a broad internal use rights, far broader than what we're seeing in draft legislation today. And also other things, access requests, the right to be forgotten, data mobility, those concepts can't really apply to de-identified data once it's been de-identified. And at the same time, the privacy laws should not apply at all to data that's at the other end of the spectrum. And I don't mean wholly irreversibly anonymous, but reasonably foreseeable is not going to be re-identified. That data should be completely out of scope of the Act to allow broader use rights, even outside of an organization, to allow us to create proper ecosystems, to learn and to create data trusts and to be more innovative in Canada. So when you think about it that way, you could say that, the twin policy goals of both protecting individual privacy and fostering business innovation are well served by recognizing some exceptions to privacy law for a subset of de-identified personal information. And while these policy goals might be easy to articulate, or at least I think they're easy to articulate, we know what we want to do. When the regulators pick up the pen and start drafting, it becomes a lot more challenging, as we've just seen. And even as Commissioner Kosseim alluded, in Ontario, the concept of de-identified data and the rules that apply to it have evolved over years. You need to consider the nature of the data involved, the reasonable expectations of the potentially affected individuals, the intended purpose for its use, the data, the environment that it could potentially be released into, and whether or not there's other linkable data, and what incentives would be out there to re-identify or prevent re-identification, and also the potential harms to the individuals. Like, some of this data would have almost no harm, even if re-identified. And so it's not so easy to, put it down in writing in a manner that works. And in fact, another issue is just the conflicting laws. Like, you'll have Quebec doing one thing and the federal government doing something else, which makes it very difficult for companies to operate across Canada with an interoperable set of rules to govern this data. So with that said, I think I'm going to turn it over to Adam so that he can kind of dive deeper into what we're seeing in practice as these regulators now are turning their minds to de-identified data. And we're seeing privacy reforms in a lot of provincial sectors across Canada, and also at the federal space with the former Bill C-11, which I'm sure will be retabled in another format early in the new year. So I will flip it over to you, Adam, to take us into the weeds of these challenges.
Thank you, Keren. And as Elizabeth, if you could put up the slide, and the first slide where it has spectrum identifiability. Just by way of background, the CANON Steering Committee, I mean, go to the next slide, Elizabeth. The CANON Steering Committee, we've had a lot of very fruitful conversations about the concepts of de-identification as they're manifesting itself in the states of data, as Commissioner Kosseim mentioned, how they're manifesting themselves in proposed legislative schemes, and including the scheme that has been enacted via Bill 64 in Quebec, which I'm going to focus comments on. One of the stated objectives of CANON is to help demystify the discussion. And early on in CANON's existence, we developed, this is an extract from a document CANON Steering Committee developed. It's called States of Data. If you go on the website, right on the homepage of the CANON website, you can access a very brief paper. And we created this spectrum of identifiability, just page and diagram. It has really been useful, at least I personally have found it useful for all the discussions we've had at CANON, for our discussions that we've had with the policy drafters and thinkers at different legislative, federal and provincial legislative schemes. And frankly, for client conversations, and for some of our clients have used this for their own internal conversations. And it picks up exactly on the comments that Keren mentioned and Commissioner Kosseim mentioned about 3 states of data. You look on the left side, you have data which is identified, a record that identifies that there's an individual. Clearly, if the individual is identified, it's personal information. And then we talk about the spectrum of a set of data. It could undergo a process of de-identification, which could render it in a state whether it fit, depending on the rigor or the nature of that particular process, it may or may not be identifiable or non-identifiable. It's all along the spectrum. And we created these working definitions. And I think the most critical piece, and it goes to a number of the comments that Keren made about a practical lens through which we have to look at the definitions, which are so central to any provisions in the Act, in these statutory frameworks that have this. You have to have the practical lens. We have to have twin objectives in mind. One is obviously privacy protection, but at the same time, the ability for organizations, whether it's public sector, health sector, or private sector, to actually be able to use the data and of course, prevent the reticence. And the phrase, if you look at the definition of non-identifiable, we had a working model of information where there's no serious possibility. We drove that phrase from judicial consideration of the concept, well-established judicial consideration in Canada. But the key frame is in the circumstances. And this is something that Canada is really focused on. And at least in some contexts, and we'll see with how Bill 64 manifested this, this allows a contextual analysis in the circumstances so that we could have helpful and useful and workable definitions, avoid circumstances where we actually have an unattainable standard of what might be non-identifiable data. Elizabeth, can you switch to the next slide? So we have here a very brief chart, which takes three states of data as articulated under the GDPR, under C11, but where I'm going to focus is on Bill 64. And you'll see the first one is personal information, and we have different words, which I will start by just highlighting Keren's point. Nothing is more critical now than the interoperability of these regimes that are going to be a domino across the country. Even difference in wording creates potential issues. But conceptually, what appears to be the case under C11, which has a definition of information about identifiable individual, well-established, consistent with PIPEDA. We have Bill 64, it doesn't use the exact same words, but conceptually seems aligned, where it talks about a concept of identifiability in the means is there's either direct or indirect means through which that a natural person could be identified. Now, the meat of the Bill 64 provisions are within the second state, and that's the intermediate state that was contemplated by Commissioner Kosseim and again mentioned by Keren in several respects of de-identified information. And you start seeing how even difference in wording of how these terms are manifested in legislative schemes actually creates some confusion sometimes. So for example, Bill 64 speaks about a state of data, a data that is de-identified, whereas the concept in Bill C11 manifests itself with the process of de-identification. I think you end up getting there, but you have one referring to a state of the data and another referring to a state. But simply and rather elegantly, I think, in Bill 64, there's a basic concept that de-identified information is basically, in a sense, the removal of direct identifiers. It actually states it quite elegantly, and there are a number of us who have a lot of pretty pointed comments about Bill 64 generally and some other provisions, but I think one does have to give credit to an elegant solution for a definition that's simple and rather, I think at first blush, quite simple to understand and perhaps operationalize. You see the standard of de-identified data in C11, and Commissioner Kosseim made a comment in reference to this. It contemplates a standard where there's the application of technical processes, that's the process of de-identifying. There's concept of reasonably foreseeable circumstances alone or in combination with other information, raising the prospect that the concept of de-identification under C11 would be much higher to meet. Data would be identified compared to what it would be in Bill 64. And we'll see in a moment how that manifests itself as potential quite significant challenges for organizations. And then quite helpfully, if you look at the third state, there is a definition of anonymous information. It manifests itself within the retention provision, but it speaks to the concept of data that if it at all times it's reasonably foreseeable, so there's a practical concept, it's reasonably foreseeable, so modified by a concept of reasonableness, but again in the circumstances. So it bakes into a contextual analysis in the circumstances, not an unattainable standards, but in the circumstances. And unlike de-identified information, it's in essence the removal of direct and indirect identifiers in that particular context. Interestingly, as you'll note, there is no definition of anonymous data under C11. But interestingly, if you look at 64, two things right at the bottom paragraph there, it talks about the anonymization of data. The anonymized data has to be anonymized according to generally accepted best practices. So this is where work, whether it's CANON or there's the CIO Council that's doing work on this, or perhaps even foreign jurisdictions, that will have to be looked at in terms of a standard to measure against, to consider whether data is in fact anonymous. And then something unique. There's a reference that to data being according to criterion terms determined by regs. There is, of course, no regs yet, but at least we have the idea that there could be regulation that would impact the process of what it takes to develop anonymous data. You can go to the next slide. Just very quick comments before we go into the broad panel discussion. So there's the terms, really the three states. Of course, personal information is littered, the concept is littered throughout, as one would expect throughout the statutory framework. But it's much more narrow and limited circumstances where a concept of de-identified data and a concept of anonymous data manifests itself. So Keren spoke to this. If you look at section 12, subsection 3, there's this contemplation of an exception to consent, which is helpful if the data, its use is necessary for the study or research purposes or for the production of statistics, and if the information is de-identified. So there's the purpose for which you'll use it, statistics, which presumably includes analytics, research purposes, study or research, and with the condition of it being de-identified. Well, that basically contemplates that the data could be technically identifiable, but there would have to be a removal of a direct identifier in order to meet that particular standard. Perhaps in many cases that would be achievable. We've had a number of client conversations. There's been discussion certainly at the CANON steering committee and one-on-one with folks, observers in the area. Even that might be a standard that can pose challenges. There might be circumstances where you actually require data in identifiable form in order to form one or more of the objectives caught by section 12.3. But the difference here compared to C11 is the standard appears to be much lower in order to at least be able to use it in this phase. And if you go to the next slide, a couple of other provisions. As I mentioned before, the concept of anonymized data manifests itself in the retention provisions. Basically, organizations must destroy information that's no longer required, or in lieu of a destruction of data, there can be an anonymization of it in order to achieve the data retention. One of the challenges with it, it's unclear exactly what it means, what it says. You can anonymize it to use it for serious and legitimate purposes. It's not clear exactly what impact that phrase will have, the extent to which it might impact the CAI would think that would limit the impact in circumstances when you may be able to anonymize it, but it does appear, just if you look at the definition, that if data is in fact anonymized, it would, by implication, have the removal of direct and indirect identifiers, and there presumably would fall outside the scope of the act. And so hopefully that does turn out to be the case, and we'll see with at least CAI guidance, hopefully sooner rather than later, and what's contemplated right there. Finally, what is happening, and we expect to see this across statutory regimes, you look at, and proposed statutory regimes, you look at section 91.3, there's an offense expressly articulated for an individual who even attempts to identify a natural person using de-identified information without authorization of the person holding the information. We'll call it the custodian, or even using anonymous information. And the kicker, of course, is the exposure for this offense. It's potentially extraordinarily severe, aligned with the provisions for multiple other offenses, up to 4% of gross revenues, worldwide turnover, gross revenues of that. So I wanted to just pause there. We had discussed the goal of having a discussion about this, and Elizabeth, you could take off the slides for now. I'm hopeful that gave a little bit of context about how the concepts of the three states are manifesting themselves, all grounded in this concept of spectrum of identifiability that both Keren and Commissioner Kosseim and Suzanne mentioned at the beginning of the session.
Great, thanks, Adam, and thanks, Keren. And as I expected, we've got some questions that have continued to come in through the Q&A in the chat. And so maybe with that first, I'll ask Pat if you're willing to put your video back on and join us here, because I have 3 questions right now that, rather than come up with my own, I think to be fair to our participants here, I'm going to jump to. And so, the first one maybe is for you, Keren, where you talked about maybe access rights shouldn't apply to de-identified data. Maybe can you expand on that a little bit?
Sorry. Yeah, so I'm thinking in the context of the bank that I work in. We might have client records on our book of records, whether it's your bank account, et cetera. So when we would pull it into a model to analyze it, we would strip away the primary identifiers and linking information and analyze it, let's just say, with other data looking for patterns. I don't know if we're looking for fraud or we're looking at credit risk. And, maybe we left one linkable piece to help us find you, let's say if you have multiple accounts, but nothing that would be, easy to identify you. And so if a customer says, I'd like access to my information, the underlying documents are still there. So your account records, your bank records, like that is what we would provide. But if you go into the machine learning environment or analytics environment, the data has been transformed and probably stripped away from you as a person and put in different formats. And while, it is foreseeable that somebody could attempt to re-identify it by, let's say linking this 5 transactions in a row with this random set of numbers and then figuring out who in the bank book of record made the same 5 transactions on those days, it would be, a monumental work effort, but I just don't think it serves the purpose, because the data is not really about you anymore. It's not about the customer, and it's about this broader model. And, there's going to be some algorithmic transparency in other sections of the legislation that'll speak to how we use information and what types of information might be used to make automated decisions about you. And so you could learn, combine that this is all the records the bank holds on me, and then my automated credit decision was made by using transactional data plus credit bureau data and, employment history to give me a credit score or something. So you can learn the types of data we use, but to then have to go back into those tables and try to pull out your data in an unstructured, de-identified format just doesn't really make sense anymore.
Great, thanks for that, Keren. Pat, here's one for you, and it sort of goes back to your remarks and when you were speaking about the 3 states of data. And at one point you sort of mentioned that aggregate statistical data as an example of zero risk anonymous information. And so the question here is, even that type of data can lead to the re-identification of individuals, depending on the small cell counts and things like that. So, to the extent you can, would you have an example of a true zero risk anonymous data?
Sure. I mean, I use that as an example of information that can, in some circumstances, be aggregated to a sufficient level to pose virtually zero risk of re-identification. And of course, Khaled and others on this in this session can speak much more eloquently about the statistical risks. But of course, small cell size, below a certain threshold of which can potentially re-identify individuals. We know that there's jurisprudence on that. There's investigative findings and research that's been done to demonstrate that. The challenge, of course, I mean, I'll give you I'll go out on a limb with a very basic example of something as benign as women are more likely than men to XXX, or, women respondents were more likely than men to whatever, is a level of aggregation which I think is unquestionably aggregated to the level that it would probably, I think, pose a zero risk of re-identification and might be an example of a sufficient anonymization. The challenge, I think, is, and the purpose of raising that is to show that there may be examples, of course, where anonymized data is truly anonymous, but the trade-off there is data utility. And, there are circumstances and contexts in which, for the purpose for which you're using that aggregation, you don't need more granularity, and it suits the purpose just fine. So I'll just leave it there, but maybe others have other comments, but that would be my example.
Great. Thanks, Pat. There's a question specifically for you, Adam, around, and this sort of ties into, Keren, what you were speaking about, where there should be an ability to use data for certain purposes. And this is where we're sort of talking about collecting data in our own right. There's a question in here and I guess for both you, Adam, and Keren, where often we see in the private sector side in agreements, more and more organizations, the primary organization is seeking to prohibit the use of anonymized or de-identified data for subsequent purposes. And so, many of us see that as an additional measure to try to protect the information, obviously, right? You limit the possibilities of re-identification if no one else can use it. But what does that sort of say to what we're trying to introduce with these 3 states of information and trying to get permission or actual certainty in the law to be able to do so?
I can offer some initial comments. I'm sure Keren will have a lot to say. I think it's probably been about, we're still in early days. It's been about 3 or 4 years, Suzanne, where we're seeing a lot more and a growing amount of discussion about an interplay of a lot of concepts within sort of service provider or data sharing arrangements, where there's a very an increasingly intense discussion about concepts of custody, control, ownership, permissible use, and then the introduction of these concepts of de-identification and anonymization. My personal experience thus far, and that's why I say it's still in the early days, is some of it just arises because of a lack of clarity about what the folks are talking about. If you're talking about, for instance, data that is anonymous, then that is totally distinct from the ability of, for example, a service provider who would use the data in de-identified, yet data could be re-identified. but it's using the data for its own purpose. And our experience thus far, I'm very interested in Keren's comments on this, is once there's clarity and simplicity with the drafting and aligning on that, and when you have two fairly seasoned parties that are talking about that, reasonability ends up weighing in, and you have a result that, again, achieves the exact twin objectives that Keren spoke about protecting privacy, certainly complying with statutory obligations that exist, and most importantly, allowing data utility, allowing the leveraging of the data for very legitimate purposes. But we're still early days, and we've already seen it again with Bill 64 and the developments in the EU with new contractual clauses. Like, it's just a stream of queries coming about, oh, how do we deal with this DPA and this addendum, et cetera. Once there's demystification of the concepts, clarity of the drafting, and a real nice distinction made between de-identified data that is re-identifiable as opposed to data that is actually rendered, quote, anonymous, whatever terminology, these issues tend to resolve themselves more quickly. Keren, I'm interested in your comments.
Yes. Yes. So part of the issue is, again, this non-binary concept, and often with service providers, subcontractors, if they want broad rights to use de-identified data, it's hard to say what that is. Their definition of de-identified might be simply stripping away name and address and leaving all kinds of other data in that can allow it to be re-identified. And so, what I was saying before about regulating in this space is it's contextual, and part of the context that you need to consider is the release environment. So when the data goes to a service supplier or subcontractor, you've now left your environment and you have less control over how the data is used and what other information that subcontractor could have to re-identify the data or link it and pool it with other data that it has from providing services to other clients. And it can kind of become a brand new set of data that you've lost control over, and could be more linkable. And it depends, again, on the probability of harm and impact to the individual. So it really depends. And we are putting that prohibition in our contracts because we want to retain control of the data, and simply saying, we have the right to de-identify your data and use it for our own purposes is just not sufficient. Whether or not that data is still subject to the act is a question of fact and law that, we need to oversee. So I would never allow a service provider to have broad rights to data that we entrusted to it. I think that would be falling short on our accountability.
The one additional comment, Keren, that I would add on now, as I look at the exact question, one of the things we are noticing, maybe a subtext or a driver for some of the increased scrutiny on this, is more organizations are looking at the data as an actual business critical asset. So when they take it and it's provided to a third party, a different environment, it's in that release environment, depending on the context, there might be extreme concern by the disclosing party about what's going to happen in that, especially given the nature of the data, which again might be business critical. So highly, highly contextual, exactly as Keren mentioned. That's exactly our experience.
So maybe to finish off here, Pat, because I actually find that this last question, this last little conversation we've had has really been critical to much of the discussion that we've had and much of the comments that have been made. And, as a information and privacy commissioner, and both when you think about the public sector and the private sector, what do you think about this concept of what Keren just mentioned? It's the release environment, and it's one thing to keep data within your organization, or your service provider keeps it within their organization. It's quite another thing when it's released out into the open or more broadly to researchers. Anything you wanted to add sort of to that discussion?
Yeah, I do. I think that's a hard case based on current wording of legislation. This idea of the within an organization versus the broader release environment to external. Right now, the law, at least the federal law as it stands, and no law in Ontario specifically, of course, but it doesn't distinguish between those two environments. On the other hand, I would, and I think there are different levels of risks, obviously. But one of the things that's really critical, even within an organization, is to have appropriate governance in place. And it goes back to this idea of appropriate segregation of duties, roles and duties, and appropriate segregation of data between departments, and with some oversight and accountability. So I think the time is right to look at that use case within an organization for certain research or analytical purposes, but I really think we need to ripen some of the governance mechanisms around that, the administrative measures, and that's one of the areas which I mentioned earlier I'd be very interested in pursuing as the IPC, if anybody would like to engage in that discussion with us. And that goes with, of course, that's private sector example, but health information custodians have been doing this all along. There is that segregation of duty within organizations, for instance, for care purposes versus research or evaluation purposes. So there are models for dealing with that. Finally, because I don't like to cop out, I just want to go back to that question you asked around, if you use personal information to create a model and then use that model to generate data, how do you deal with that model, and should it be regulated? I just would want to leave with two general points for consideration. That model, much like de-identified data, I would think two key considerations would be, one, transparency with regard to the uses you put that model to, much like de-identified information. So I think transparency is key, and also rules are governing, and preventing using that model in order to re-identify individuals, much like the new generation of offense provisions that we're seeing in legislation. So that's my feeble attempt to answer a very complex question, but I did want to go back to it because I did promise to think about it a little bit.
Thanks, Pat. And, we're already 4 minutes over. I apologize, everybody. I think we knew it. We were going to have lots of questions, and we really just scratched the surface. But a lot of great content, some good conversation. Thank you, participants, for the questions that you provided in the Q&A in the chat. And with that, I will close off this CANON webinar and wish everybody a good afternoon. Thank you, everybody.
Thank you.